for delivery of judgment. Item 1, PIL Sumoto 1/2020 with IA Civil 1538/25. With IA Civil 1538/25. Civil 1538/25. Civil 1538/25.
Okay. We have taken note of the submissions made by all sides. We have noticed that the Union of India is vehemently objecting to the power of the legislature of the state of Nagaland to enact Nagaland Petroleum and Natural Gas Regulations 2012 and the Nagaland Petroleum and Natural Gas Rules 2012 on the account of lack of legislative power. We have noticed that the India is vehemently objecting to the power of the legislature of the state of Nagaland to enact Nagaland Petroleum and Natural Gas Regulations 2012 and the Nagaland Petroleum and Natural Gas Rules 2012 on the account of lack of legislative power. Here, the India is vehemently objecting to the power of the legislature of the state of Nagaland to enact Nagaland Petroleum and Natural Gas Regulations 2012. 3/2026.
No.
Yeah, sorry, but we can't help it.
No.
Okay. Yes.
Supplementary item 11 for motion. WBC 1414/2026.
None appears on call for the question. Our sponsor appears for the present for the respondents. It is at page 119, dated 12/12/2025. Passed by so and so in the key reference. Case number so and so, so and so, so and so, by which the petitioner was declared to be a foreigner of 1971. Notice it has been forwarded call for the acknowledged. Extra officer in 2 days. Here meeting this petition for bail is opposed by the Honorable Secretary Person for the appeal of auto motors. Considering the conviction, 10 days time to take bail of the police department to the satisfaction of
SP voted wrong.
Daily list for admission. Item 1 with 2.
What is, my lord, the judgment was passed, my lord, the single judgment only depend upon the one judgment of the Delhi High Court, my lord, which was confirmed by the apex court, my lord. My lord, the judgment, my lord, reflected in the impugn judgment of the learned single bench, my lord.
See the paragraph 21.
Paragraph 21. Yes, my lord. That doesn't allow. Paragraph 10. Aforesaid recommendation of pay commission leave no rooms doubt in the mind of the
Just one. Yes.
no room of the doubt in mind of this court that the case of the person squarely covered by the determination made by Delhi High Court in DGOF Employees Association affirmed by the apex court of in Indian in so and sixth pay commission itself concluded that the parity has long been established. My lord, here in this particular case, my lord, this I'm giving this the department pension that my lord, that now I have placed before this honorable court, my lord. Here, my lord, serial number 10, my lord. Dear my lord, fourth pay commission, their scale was, my lord, 1400 starts from 1400, my lord, and my lord, this another, my lord, their my lord, fifth commission, their scale was 5000, my lord, and now, my lord, it was marched to, my lord, 6500, my lord. And my lord, serial number 11 is concerned, my lord, this pay scale 1640, my lord. It was subsequently 55, my lord, and now, my lord, it was, my lord, 6500, my lord. So, my lord, there is no historical parity, my lord. This, my lord, is initially those the respondent, my lord, they are receiving in fourth pay commission, my lord, 1400, my lord. And their subsequently fifth commission, their scale was, my lord, started from 5000, my lord. And my lord, those who are, my lord, they claiming, my lord, in the particular the employees association judgment, which confirmed the apex court, my lord, their in fourth commission, their salary was 1640, my lord, starts, my lord, and my lord, fifth commission, it was, my lord, 5500. Here, my lord, is so far, my lord, secretary staff, my lord, their salary was, my lord, the serial number 11, my lord, scale, my lord. Only this is the only my point before the honorable court, my lord. This historical parity, my lord. There is no historical parity in between the respondent and the central civil service secretary staff, my lord. In that particular case, it was rightly, my lord, to pass the order, my lord, which was reflected in paragraph 21, my lord. Another thing is, my lord, the so far, my lord, central secretary service, my lord, they are directly recruited, my lord, 75%, my lord. And so far, dear, my lord, the nature of the work is completely different. That is different thing, my lord. So far, my lord,
We
this,
have not introduced the facts as to whether the two classes of officers of the same grade, why they were given to different pay scale. That you have not even told us.
my lord, only this order was passed, my lord, on the depend on the historical piety, my lord, this, my lord, this judgment of the referred by in the judgment, my lord. That was, my lord, this same pay scale, my lord, in 2000, fourth pay commission was the fifth pay commission also, my lord. So subsequently, my lord, this Central Security Service, my lord, the 2006, my lord, when the pay commission before 10 days, my lord, it was enhanced, my lord. So their claim was, my lord, because of that, if they are the same from same pay scale, my lord, why they are not entitled, my lord? As so, the honorable, my lord, the Delhi High Court considered their claim, my lord, and apex court confirmed, my lord. Here, my lord, they are getting, my lord, the less scale, my lord, historically, my lord. And the work structure, my lord, and the work nature, and the employment also, my lord, there is 75% direct recruitment, my lord, in central civil service.
Without introducing the facts, how will you understand what you are trying to say?
My lord,
Without introducing the facts, how will you understand what
Yes.
you are trying to urge?
Here case is, my lord, this they are claiming in the requisition is that, my lord, this and my lord, they are not getting equivalent pay scale and grade pay, my lord. Relating to Central Civil Service, my lord. Here, the Central Secretary Service, my lord. These respondent, they are working, my lord, in some Central Civil Service under Central Civil Service, my lord. But those who are, my lord, they are comparing the pay scale, my lord. They are, my lord, Central Secretary Service. Their scale was different, my lord. Now, subsequently, they are given some another benefit.
What we understand is that for those people who were promoted prior to 1/1/2006 to 14/9/2006, they were offered to get their fifth to sixth central pay commission switchover pay subject to fitment table of 7,450. Correct?
Yes.
Now, that is from the date of their last promotion, and they were given that option. And therefore, they migrated to that scale, and they got a higher pay scale, right? Now, why would you deprive somebody who has not been offered the same scale? You offered migration to be some of them. Why these people are not given?
There, Central Secretary Service, there's work nature is different, my lord. And here, they are in field work, my lord. So for my grounds of the appeal, your lordship, my previous, my lord. My lord, the grounds, my lord, for the predefined scale of the applicable to the post of assistant and personal assistant in Central Civil Service Secretary 5,500 to 9,000 as on 1/1/2006. However, before the constitution of Sixth Pay Commission, scale of the post of assistant senior grade C of the Central Civil Secretary stenographer service was upgraded.
Mr. Mehdi, we are not being able to follow you. We are asking you a specific query. Our query is that for people from the same pay grade, some of them you offer a higher pay grade and they migrate to it. Is that understanding of the court correct or wrong?
So for grade pay is concerned, my lord. Well, grade pay, my lord.
Grade pay, scale pay, whatever you
Yes,
say, doesn't make much of a difference.
My lord,
The understanding which you are having, whether it is right or wrong.
My lord, completely judgment was passed on the basis of the another judgment, my lord. That was the case, my lord, the historical priority, my lord.
That's why, Mr. Mehdi, you are asking only one question. Whether this understanding of the court is right or wrong.
Because of that, I approached this honorable court,
No, you did not approach. They approached saying
no,
that the,
now they file appeal, my lord.
but what is wrong then? What is incorrect? If that
This only one point is, my lord, this judgment was first, my lord, the historical priority of the both, my lord, central, this association.
Friends, what do you call a history? From which year you start calling a incident to be a history?
My lord, this judgment was first, my lord, historical priority, my lord. This is my priority, my lord.
Because that parity, that is why we are understanding also the same thing. Parity means you two people who are drawing 100 rupees salary. Out of them, you offer one of them upgradation. They go there. So why do you have pick and choose? Only few people to have been upgraded to another scale, and then you say there is no disparity. They were historically in a different cadre.
My lord, the historical scale was different, my lord. So, my lord,
Why did you offer few of them?
my lord, in from some 6 pay commission, my lord, this we are paying the same, my lord, same thing, my lord. But this when secretary service, my lord, they are before the 6 pay commission, my lord, they are given another scale, my lord. So ground number A, my lord. The central was upgraded to scale on 6,500 to 10,000 with effect from 5/9/2006 by order 25/9/2006, keeping the view that the perceived anomaly in a pay scale of administrative so-and-so, vice president, so-and-so, central board, so-and-so. The upgradation was done on exception specific to the
No, Mr. Mehdi, it doesn't take you anywhere. You see, the projection made by the petitioner is to the effect that their upgradation of pay took place 10 days prior to the constitution of six pay commission.
Yes, my lord.
And then you start saying that they are placed in a different pay scale.
Understand, my lord.
So why you 10 days before that exercise took place?
My lord, I understand, but my point before this honorable court is that, my lord, the Delhi High Court judgment, my lord, they already received the same pay scale.
You know, it was same.
My lord,
10 days before that exercise, you changed the pay scale.
no, my lord, I am not that, my lord. I am saying my submission is before this honorable court, my lord. The 5,500 scale was received at that time, my lord, and before 4th pay, they are getting same pay scale, my lord. So far, so far this assessment is concerned and central security service, my lord. So they are the same. But subsequently, for central civil service, my lord, the security service, my lord, their service there it was enhanced, my lord.
Where is the document relating to the offer to few of them to be upgraded? Where is that?
Your Lordship, if I may just start from the beginning.
Just a query, then we
Page
come to you.
86, Your Lordship.
86,
86 is the one, that order of 25/9,
86.
86 of the rate appeal of 25/9/2006. Not 86, Your Lordship, page number 89, sorry. 25 September 2006. This is the upgradation, just 10 days prior to the constitution of the 6th CPC. And this is with effect from 15 September 2006. Your Lordship may kindly note down that date, 15 September 2006. In order to be upgraded to the next, the higher grade pay under 6th CPC switchover, they have to draw that earlier 7,450 as on 1/1/2006. But here the letter itself shows that 15 September 2006.
We'll hear you, don't worry.
Yes, sir.
My submission before this honorable court is, my lord,
He is
so,
not permitted to prejudice us before he starts, if he completes.
my lord, my point is, my lord, only one point is, my lord, this, my lord, these judgment, my lord, so far, this, my friend is now read, my lord, this, it, 89 is concerned, my lord. This was, my lord, for that, so that particular association who, before the Delhi High Court, my lord, their, my lord, scale was 5,500, my lord. And, my lord, only they were deprived, my lord, subsequently, the central secretary service, there, it was, my lord, effect for them, my lord. So my only submission before the honorable court, my lord, for that, my lord, the apex court, my lord, as well as the Delhi High Court rightly passed the order, my lord. So my submission before this honorable court, my lord, this now this respondent are, my lord, they are receiving, my lord, less pay scale, my lord. Not like the particular association, my lord.
What's the difference between the pay scale of these two?
Well, pay scale, my lord, I've given the cert, my lord, the cert, my lord.
Just tell us.
My lord, this, my lord, serial number 10, my lord, it was, my lord, started from 1400, my lord. 17.
No, we will need the pay scale at the time when the dispute started. That is, in 2006, what was the pay?
Yes, my lord, but here judgment was first, but they are historical parity, my lord. Same, so their parity as well, this order was passed, my lord. It was not that, my lord, their difference was that, but in particular case, my lord, the Delhi High Court, my lord, their scale was same, my lord. Their scale was 1640, serial number 11, and it was subsequently 5,500. And in the particular respondent, they are receiving 1,400, my lord, subsequently 5,000, my lord. So, and their work nature and everything was different, my lord. So my only submission is that there is no historical parity between the this respondent and those who are working in the central secretary service, my lord. This only one point before this honorable court, my lordship, because the entire judgment was passed on the basis of the historical parity. Paragraph number 24 of paragraph number 24 of the judgment, my lord. The accordingly reason recorded herein above, the present petition stand allowed in terms of determination made by the so and so association supra. It is held that petitioner treated as equal to the same employer and enjoy equal pay, all benefit following pay. Consequently, directed the respondent are required to fix the pay of the petitioner in the same pay scale as given to the similarly placed so and so. In the ministry with effect from so and so, consequently, pay fixation and treatment order shall be issued so and so, my lord. So, my lord, this in the particular case, my lord, this OM was set aside, my lord, but it is
shows the document by which the scale of pay of Central Secretariat Services was fixed, which is the document which shows us the pay scale of Central Secretariat.
My lord, Central Secretariat Service, their scale, my lord, it was, my lord,
8,506.
my lord, it was, my lord, 5,500, my lord.
Yes.
Well, that is my point, my lord.
Yes.
Your Lordship, if I have to start, then I'll start from beginning. The petitioners, the respondents are office assistants, supervisors, stenographers in that particular scale of 4,500 to 5,500. Somebody is in 4,500, somebody is in 5,000, somebody is in 5,500. Now, they belong to an organization which is considered to be a field organization. And as to
You are
what
from the scale of 4,500 to 5,500.
5,500. So some of the petitioners were belonging to the post of supervisors who were drawing the scale of 5,500. The assistants were drawing 5,000, and certain assistants were drawing the scale of 4,500. And here they belong to the borderers organization, which is considered to be a field organization. Now, to come to that particular point as to what constitutes a field organization and what is the central secretariat organization. So that explanation can be found in the report of the 6 CPC. Now, if I may take your lordship to the 6 CPC, which starts at page number 91. Your lordship, I have a clear copy of the 6 CPC report because that would actually be helpful because it is not clear. Somehow I find it not clear in the reader page. This your lordship will find from 91 onwards, this chapter 3.1. Now, if I may take your lordship to para number 3.1.1 as to what constitutes a field organization, what is the central secretariat organization. Now, if I may just read, the various secretariats of the ministries and departments of Government of India together constitute the headquarters organization. The secretariats are chiefly involved in matters relating to formulation of policy and ensuring that these policies are executed in a coordinated and effective manner. Actual execution of these policies, however, is left to field agencies outside the secretariat, which may be either attached or subordinate offices of quasi-government, autonomous, or public sector entities. Now, disparity between secretariat and field offices. This is important, Your Lordship. 3.1.2. The central administration.
Whether there's any notification by the central government,
Yes.
accepting this recommendation of chapter 3.
Yes.
31.313. What is that? 31.
Yes.
Accepting it, is there a notification?
Yes, Your Lordship. That notification, Your Lordship, at page number 100. To get through a gazette notification, this particular at page number 101.
All have come to grade pay of 4,200.
4,200. Now, this is where I'll take your lordship to where the disparity actually happened. As I stated earlier at page number 106, right? notification OM dated after this revised pay rules at page number 106. They came up with this particular OM wherein only Central Secretary Service Officer assistants were granted this scale of 6,500 as on 1/1/2006. As I mentioned earlier, Lordship, at page number 89, the order says with effect from 15 September.
That otherwise we'll not understand.
Yes, page number 89, Lordship. Where the disparity actually happened just 10 days prior to the constitution of the 6th CPC. And this has been discussed in the 6th CPC report also, this particular upgradation. Upgradation of
Just
scale of assistance
Just
and
now, when-
yes, page 89. 89. Lordship, may I read it out or Lordship has come to page number 89?
You can see relevant part.
Yes. The undersigned is directed to say that the issue of perceived anomaly in the pay scale of assistance of PAs in the CSS and CSSS via vis-a-vis inspector and analogous posts on CBTT, CBEC has been engaging the attention of the government for some time. It has now been decided that the pay scale of the post of assistance in the Central Secretariat Service and the person assistance Stenographer C of the Central Secretariat Stenographer Service shall be upgraded to the scale of 6,500 to 10,500. This upgradation has been done as an exception specific to assistance of CSS and the steno grade C of CSSS only and will take effect from 15 September 2006. Your Lordship, the question of historical parity or for that matter parity in pay scale, Your Lordship, I accept that particular fact that this particular exercise is best left to organizations who are expert in this. And this has been stated by held by the Honorable Supreme Court as well as this court that with regards to pay parity, pay fixation matters, the pay commission are the best judge of the issue. Here, the pay commission itself raised this issue because the government ultimately referred this issue to be settled by the pay commission, the 6th CPC. Now, if I may take your Lordship to the 6th CPC report, which is at page number 91. Here, as I was reading from para number 3.1.2, here, I'll just read out your Lordship. The senior administrative posts in the Secretariat are mainly filled by officers of All India Services and Central Group A Services on deputation under the Central Staffing Scheme. Some of the posts in the mid-level are also held by officers of the Central Secretariat Services, Railway Board Secretariat Service in Ministry of Railways, Defence Forces Headquarters Services in Ministry of Defence, and by Indian Foreign Services in Ministry of External Affairs. Historically, various services in the Secretariat have been given an edge over analogous posts in the field office. This was done on the ground that office staff in the Secretariat performs complex duties and are involved in analyzing issues with policy implications, whereas their counterparts in field agencies perform routine work relating to routine matters concerning personnel and general administration, etc. Another argument that is used to justify the edge for various posts in secretariat is that in secretariat, level jumping occurs and personnel in the grade of assistants or etc. submit files directly to decision-making levels of undersecretary, deputy secretary, etc. Higher pay scales in the secretariat officers may have been justified in the past when formulation of proper policies was of paramount importance. The present position is different. Today, the weakest link in respect of any government policy is at the delivery stage. This phenomenon is not endemic to India. Internationally also, there is an increasing emphasis on strengthening the delivery lines and decentralization, with greater role being assigned at delivery points, which actually determines the benefit that a common citizen is going to derive out of any policy initiative of the government. The field officers are the cutting edge of administration and may in most cases determine whether a particular policy turns out to be a success or a failure in terms of actual benefit to the consumer. Accordingly, the time has come to grant parity between similarly placed personnel employed in field officers and the secretary. This parity will need to be absolute till the grade of assistant. Beyond this, it may not be possible or even justified to grant complete parity because the hierarchy and career progression will need to be different, taking in view the functional considerations and relatives across the board. Now, here 3.1.4 is very important. As my senior was saying about the historical parity, about the question of historical parity. A parity has long been established between the posts of lower division clerk and upper division clerk, UDC and LDC, in secretariat and field office. This was the parity which was discussed in on the Supreme Court judgment also. And I am also on this particular issue only. Only because of this disparity which occurs after the scale of UDC. This is where I'm actually, and this is where the on the 66 CPC discusses it. The position becomes different for posts above UDC level, with the assistant in secretariat offices being placed in higher pay scale vis-a-vis those working in field offices. Earlier, the respective pay scales of 5,500 to 9,000 and 5,000 to 8,000 existed for assistants in secretariat and in field office. This disparity was aggravated in 2006. Your Lordship may kindly note this 2006 of page 89, when the government further upgraded the pay scales of assistants belonging to Central Secretariat Services to 6,500 to 10,500. This upgradation, apart from increasing the existing chasm between similarly designated posts in the Secretariat and field officers, has also led to an equal situation where the feeder post of assistant and the promotion post of section officer have come to lie in an identical pay scale. Now, disparity between CSS and other secretary services after 2006. Further, it has also caused a hiatus between similarly placed posts in different secretariats because the higher pay scale has been limited to the assistants belonging to CSS only. Assistants working in other secretariat organizations, the AFHQ, ME, and other various other non-participating ministries have been denied this and are stringently demanding similar pay scale, higher pay scales from the government. Now, if I may take your Lordship to the recommendation part, that is very important here with regards to recommendations for the central secretariat organizations. In this report at page number 1, internal page 162, and at page number 95 of the writ appeal. Since it is not clear, your Lordship may refer to the printout I just gave your Lordship. Internal page 162. Here at para 3.1.2, the scale of the assistance in the secretariat organization, central secretariat organization was pegged at 6,500 to 10,500. 3.1.2. And thereafter, next page itself, for the non-secretariat organization, that is the field organization, the 6 CPC recommended at para 3.1.4. Lordship may kindly refer to the table here. All these scales of 4,500, 5,500, 5,000 and 6,500, all of them were merged to be included in the recommended pay scale of 6,500 to be at par with the Central Secretary Services. And the grade pay that was recommended was 4,200. Thereafter, after this six CPC recommendations got accepted by the government, and at page 10, also, Your Lordship, if I may take Your Lordship to page number 99 of the writ appeal, wherein this 3.1.4 was also directed to be applied to assistants serving in the borderers organization. The 6 CPC report itself at para 7.3.39.24, parity with secretary.
Yes.
7.3.39.24. The administrative cadre has demanded higher pay scales on par with those existing in the secretariat. The commission has already recommended parity between similarly placed posts in headquarter organizations and field offices in chapter 3.1 of the report. These recommendations will be extended in the extent case as well. So for borderers organization also, same recommendations were recommended. And thereafter, the 6 CPC report at page 100, through gazette notification, the government came up with this 2006 revised pay rules 2008 on 29th of August 2008. The Lordship may note down the date, 29th of August 2008. And at page number 102 of that same gazette notification, page 103, the field offices, secretary, head clerks, assistants, stenographers were all given this grade pay of only 4,200. But at page 102, the respondents took the benefit of this particular upgradation of merger basically at point 2, section 1.2, revised pay scales for certain common categories of staff at serial number 2 on account of merger, page 102. On account of merger of pre-revised scales of 5,000 to 8,000, 5,500 and 6,500 to 10,500, some posts which presently constitute feeder and promotion grades will lie in an identical grade. And this was also observed by the 6 CPC in its report. The specific recommendation about some categories of this course made by the Pay Commission are included in section 2 of part B. As regards other posts, the posts in these 3 scales should be merged. In case it is not feasible to merge the posts in these pay scales on functional considerations, the posts in the scale of 5,000 and 5,500 should be merged with the posts in the scale of 6,500, being upgraded to the next higher pay scale in PB2, that is to the grade pay of 4,600, corresponding to the pre-revised scale of 7,450. In case of a post already exists in the scale of 7,450, the post being upgraded from a scale of 6,500 should be merged with a post in a scale of 7,450 to 11,500. Now here, if I may take a break, Your Lordship, here, this particular line, what they took, they mistook this particular line as if because it says that those which existed, if it was a feeder post or promotion post only, this upgradation to 7450. And when, if they are drawing this 6,500 as on 1/1/2006. Now, this particular analogy was carried forward to page 106. When they came out with the OM dated 13
1/1/2006 is not there.
106, you know,
Okay,
106.
1/1/1/2006, yes, okay.
106, and that's
Yes.
a P7 of the.
Yes.
Therein, they took this particular P and they upgraded this grade pay of 4,200 to 4,600 only for secretariat. So everything that was done by the 6 CPC was totally diluted to this particular OM. And another one at page 109, wherein they denied this 4,600 grade pay to the petitioners, that is the field organization assistants, stenographers, only on the ground that they were not drawing as on 1/1/2006. If I may recollect, your lordship, here on 1/1/2006, neither the secretariat assistants were drawing this, nor the field organizations, they were not drawing at all. So they were drawing, the secretariat organization assistants and stenographers were drawing from 15/9/2006 as per page 89. But they mistook this particular drawing of this 6,500 as on 1/1/2006. And this totally becomes clear as daylight at page 109. Wherein they came out with another OM just 3 days after this.
Give an example of daylight, then you will miss. You don't have daylight.
Yes, your lordship, here we don't have that daylight. Here, after 3 days itself, where they denied this 4,600 grade pay to field office assistants, by this OM dated 16/11/2009, page 109. So if I may just read out, your lordship, consequent upon the notification. Consequent upon the notification of CCA's revised pay rules 2008, Department of Expenditure received a large number of references from administrative ministries and departments proposing upgradation of the posts which were in the pre-revised scale of 6,500 to 10,500 as on 1/1/2006 by granting them grade pay of 4,600 in the pay band 2. After considering the matter, white OM of event number dated 13 November 2009, page 106. The government has approved the grant of pay structure of grade pay of 4,600 in the grade pay in the pay band 2 to posts that existed in the pre-revised scale of 6,500 to 10,500 as on 1/1/2006. This is wrong, your lordship, because at one instance, the same departments, white 25th September OM dated 25th September 2006, which is at page number 89. They said that this is with effect from only 15 September 2006. And write this OM of 16 November 2009, 3 years after, in fact, 1 year after the 6 CPC recommendations are accepted, they came out with this particular false analogy that as on 1/1/2006, the stenographers and the secretariat assistants were drawing 6,500. So, next page, your lordship. Next page is important here. How they denied this particular grade pay of 4,600 to the field office assistants. How they diluted the recommendations of the 6 CPC. While considering the para number 4, while considering the case of granting upgraded grade pay of 4,600 to assistants and PAs in the central secretariat, it is noted that 6 CPC had recommended parity in terms of hierarchical structure of office staff in field and secretariat offices up to the level of assistants. And this recommendation had been accepted by the government. However, One of the reasons due which assistants of Central Secretariat are being granted grade pay of 4,600 is the fact that there is an element of direct recruitment to the post, and that too through an all India competitive examination. With the issue of this department's OM of event number dated 13 November 2009, the grade pay of 4,600 has already been introduced in the case of office staff and field officers. As far as Central Secretariat is concerned, in order to continue to maintain parity between field and Secretariat officers, introduction of level in the hierarchy of Central Secretariat having grade pay of 4,200 in the pay band PB2 between the grades of upper division clerks and assistants is necessary. So they denied this 4,600 grade pay only on the ground that there is an element of direct recruitment in Central Secretariat services. But here in field officers, there is a promotional post, UTC to assistants. So here, I'd just like to place one particular judgment of the Honorable Supreme Court, wherein the Honorable Supreme Court has held that if the incumbents are undertaking the same nature of work and doing the same kind of work, even though their recruitment structure is different, but they are entitled to the same pay scale. So this analogy that just because they are recruited, some of them are recruited directly at para number 3. If I may just read out, Your Lordship. I'd like to read out from the third paragraph of para number 3. Now these appeals have come up for hearing from that line. Just something. Yes. Now these appeals have come up for hearing. We find that the nature of duties being discharged by the youth coordinators who have come on deputation and have been absorbed as such, and those who are directly recruited on fixed term are discharging the same duties. The only difference is the source of recruitment. Once the deputations are discharging the same duties and are being paid salary and other allowances, then there is no reason to deny the same benefits who are discharging the same duties and functions. Those deputationists now observe obtained the order from this court, but the direct recruits did not approach this court. They were treated as a class apart because of the source of recruitment. Once these persons are already working for more than 2 decades, discharging the same functions and duties, then we see no reason why the same benefit should not be given to the respondents. Looking to the nature of and duties of the respondents, we have the opinion there is no reason to treat them differently. However, at the time of admission, this court on confined the relief from the date of filing of the writ petition. The rest is not important, Your Lordship. So here, almost Supreme Court also held that if they're deciding the same duties and undertaking the same role, and this has been not established by a court of law, this has been established by an expert body, that is a 6 CPC. They themselves, 6 CPC has stated that they are undertaking the same duty, that's why they need to be given parity in pay scale. And the respondents, the Department of Expenditure personnel, they mistook this whole analogy and tried to give their own color. Here, now I'd like to take your lordship to the Delhi High Court judgment on which the Honorable Learned Single Judge relied upon, which went on to be affirmed by the Honorable Supreme Court, and as to how the petitioners, the respondents, are similarly placed as the petitioners in that case. Now, here in the Delhi High Court judgment, it starts at page number, I've annexed it in my rejoinder, at page number 211. Here, your lordship, the judgment starts at page number. No, it's a border roads organization. It's a, it comes under Ministry of Defense. Yes. They are otherwise, they are governed by the CCCC rules because they don't have the individual set of service rules.
Civilian service. There are two types, madam, from
Lordship, that is what, they have a hybrid structure. Why? Because it has been held by this honorable court, in R. Vishwan, the honorable Supreme Court, in fact, R. Vishwan judgment. The borderers organization, because of its structure, is such that it is 50% manned by army personnel and 50% by civilian personnel. And since it comes under the nature of under the Ministry of Defense, and it's a uniform force, that's why the Honorable Supreme Court has held that CAT jurisdiction doesn't count. In fact, it emanated from that judgment, emanated from a judgment delivered by Honorable R. Vishwan, you know,
okay.
R. Vishwan, Viswan, N. Vishwan. That's what Viswan. V for victory. Victory. Your Worship. Also, Your Lordship, after this judgment, R. Vishwan, There is another judgment wherein Mohammed Ansari versus the Union of India. That judgment is more clearer because in that case, the petitioner approached the CAT, and then after getting relief from CAT, the Department Union of India approached the Honorable Division Bench. And Division Bench, the judgment which fell from Honorable Justice Ansari as it then was, that borderless organization doesn't come within the ambit of CAT under the Administrative Tribunals Act. And then the petitioner, the Mr. Mohammed Ansari, he approached the Honorable Supreme Court. And the Honorable Supreme Court upheld the judgment as pronounced by this Honorable Division Bench of this Honorable Court, that borderless organization doesn't come within the ambit of Schedule 1 of the Administrative Tribunals Act. And they have to approach the Honorable Gauhati High Court. I know that case because I represented Mr. Mohammed Ansari, and he got the relief after approaching this Honorable Gauhati High Court. So the judgment is WPC 4074 of 2012. Yes. Dated August 2nd, 2013. So at that point of time, I was in Delhi, so I could not represent him. Afterwards, I represented him when the Supreme Court referred the matter back to the Gauhati High Court to decide the issue on merit. It was decided in favor of the petition. So here, if I may take your lordship to page number 211, where the Delhi High Court judgment starts. It was filed by the DGOF Employees Association. DGOF is Director General of Ordnance Factories. It also comes under Ministry of Defense, same ministry, just like Workers Organization. And it was also field office, field organization. Yes. I understand. But it is manned by people from DGOF. They are governed by the CCSCC. Now, the structure of Workers Organization is such that it is comprising of 50% civilian employees and 50% who are sent from army. Yes, ordnance sometimes. But the manning policy of Director General of Ordnance Factories, the army personnel is not that much as in Borders Organization. So because of that, only R. Vishwan said that even though they are an integral part of the armed forces, that is what the R. Vishwan judgment said, but they will never be governed by the army, and they will not get those allowances under the army. And here the DGOF Employees Association, they were basically aggrieved by the same upgradation at page number 89. That is the 25th September 2006 upgradation to 6,500 of the secretary. And there, this we find at page number 213 at 8th line from the bottom, from the line. It is submitted in this background from that line onwards. It is submitted that in this background, when the 6th Central Pay Commission recommendations were pending consideration of the central government and upgradation of the existing pay scale from 5,500 to 6,500 for the assistance PAs was sought to be given to employees in the CSS and CSSS by an order of 15/9/2006. And ultimately, I won't take that much amount of time going to the whole judgment. I'll just go to the operative portion of the judgment, wherein the Honorable Delhi High Court held that this particular upgradation is not correct, and they should be given the same scale grade pay of 4,600. At page number 235, para 24. Here the question of parity was till the stage of UDC, not assistance, Your Lordship. Because of the disparity in the assistant post only, we approached the High Court. Otherwise, if there had been parity or disparity for the matter, we would not have approached, Your Lordship. After UDC level, there was disparity, and this was accepted by the 6 CPC in its report also. So to correct that disparity, same grade pay was recommended, but the Secretariat of Assistance took a march and they got a higher grade pay of 4,600, and that is where we are aggrieved. So if para number 24, the Honorable Delhi High Court, they also discussed the recommendations of the 6 CPC at para 3.1.4, which I had highlighted on the earlier occasion, Your Lordship. This particular judgment was again referred to the department approached the Honorable Supreme Court. Your Lordship, I am placing the Supreme Court judgment on which the Honorable Division Bench also relied upon. The Union of India went in appeal against the judgment rendered by the Honorable Delhi High Court. And if I may take your lordship from para number 10 onwards of this Honorable Supreme Court. Here, para number 15 would sum up the whole gist of this argument, wherein the Honorable Supreme Court held that this particular case is not a case involving equation of two sets of employees in two different organizations. No, courts would not look into that particular issue. This is a case wherein, keeping in mind the recommendations of 6 CPC, the applicability of pay scales recommended by the 6 CPC should have been done. But since there was a discrimination which occurred with regards to granting of a particular grade pay and pay scale to one set of employees and not granting it to another set of employees, that is why the law as held by the Honorable Delhi High Court was good law, and as such upheld by the Honorable Supreme Court. Para number 15. And coming to para number 15 of this 15, para 10 onwards, Your Lordship, the Honorable Supreme Court ultimately summed up in para number 15. Yes. Now, your lordship, if I may take your lordship to the judgment of the honorable learned single judge. And how the facts of the issue involved in both those writ petitions of the honorable, which was there in before the honorable Delhi High Court, as well as this particular court, your lordship, how it is similar, and how the similarity was drawn by the learned single judge. At page number 32, your lordship. Para 15 onwards. Page 32, para 15. In the case in hand, there is no dispute that the petitioners are also.
Yes, sir.
Yes, sir.
32, no?
32. In the case in hand, there is no dispute that the petitioners are also treated to be unequal on the basis of the officer memorandum dated 25/9/2006, inasmuch as they also discriminated against the counterpart in CSS. There is also no dispute that under the ministry, certain persons are under CSS, that is, those who are posted in the Secretariat's office at New Delhi, and others like the petitioners who are posted in field services, and such field services include the Borderers Organization, Director General of Ordnance Factory, etc. The writ petition before the Delhi High Court was referred by the employees of Ordnance Factory, and the present petitioners are employees on the Borderers Organization. Admittedly, both are field officers under the ministry, and both were aggrieved by the same decision. The DGF Employees Association initially challenged the impugn action before the CAT, and the petitioners referred the present batch of writ petitions before this court. In the aforesaid backdrop, let this court first take note of the recommendation of the 6 CPC. So 6 CPC recommendations were looked into by this honorable court, and thereafter, as also with regards to the applicability of the 6 CPC recommendations to the Borderers Organization, which I pointed out earlier. So coming to page number 37, para 21, the honorable learned single judge held the aforesaid recommendation of the pay commission leaves no room for doubt in the mind of this court that the case of the petitioners is squarely covered by the determination made by the Delhi High Court in DGOF Employees Association, Supra, affirmed by the Honorable Apex Court in Union of India versus DGOF Employees Association and the Supra, and that 6 CPC itself concluded that the parity has long been established. So ultimately, the writ petition was allowed. So that's, in my humble opinion, Your Lordship, there is nothing wrong with the judgment impugned in this instant rate appeal, Your Lordship. As such, it should be dismissed.
My lord, so far my learned friend, they cited one judgment relating to nature of the work, my lord. One deputation, my lord, their nature of the work and the permanent appointed, my lord, directly in their same, my lord. In same establishment, my lord. Here, they are completely different, my lord. They are, my lord, in another establishment, they are another establishment. So my humble submission that judgment may not be the covered this particular aspect. Another thing is, my lord, so far the Apex Court judgment, my lord, which was upheld by my learned friend cited, my lord, relating to the particular the association, my lord, this the DGOF, my lord. In paragraph 14, my lord, it is discussed, my lord. As noted by the High Court, it is evident from the parity of the pay scale so and so and so was maintained prior to 1186 under the third pay commission recommendation. for period of 1973 to 1/31/3/85. The priority was continued in fourth Central Pay Commission recommended with respect from 1/1/86 to 31/2/95 and fifth pay promise itself. So, my lord, here discuss the everything, my lord. This it is historical priority, my lord. So in that case, my lord, here, my lord, this particular judgment, my lord, the so far the DGOF, my lord, Apply Association, my lord, everything was similar. It's similar, my lord, similar to the Central Secretary Service, my lord. I've already given the chart, my lord. There, that chart is reflect, my lord. That sir is reflect in serial number 10 and 11, my lord. So for 10 is concerned is related to the respondent, my lord, the present respondent, my lord. So for 11 is concerned, my lord, so this is related to, my lord, this the employee association of the DOGEF, my lord. DGOF, my lord, their scale was, my lord, this scale like serial number 11, my lord. And so far, my lord, the Central Civil Secretary Service, my lord, they are also same scale, my lord. So that, my lord, this whatever the judgment was passed in particular, which was affirmed by the apex court also, my lord, it was completely different from this the respondent, my lord. So this and on the, my lord, this when they this learned single judge discussed this, my lord, this paragraph 13 itself, my lord, of the page 31, my lord. The Delhi High Court in DGOF Employee Association so far relating to the impugned notification 25/9/2006 concluded following. When setting aside the notification 25/9/2006, it was discussed the priority between CESS employees and other existed for 10 years, even after fifth pay commission and its implementation. The singular event that brought out the sense was not the result of sixth pay commission recommendation. It was the intervention upgradation of the pay scales existing so and so. Second, there 4-decade priority. There were 4-decade priority, even 1 decade after fifth pay commission, and such priority was not disturbed, was sought to be disturbed on the recommendation of 25/9/2006, just prior to 6 pregnancies. So here, my lord, discuss, my lord, their initial from the last 10 years, my lord, their scale, my lord, and whatever is the less, it was similar to the Central Secretary Service, my lord. So for this DGOF concerned, my lord. Here, respondent, they are not similar. Their scales, my lord, in the fourth pay commission was different, my lord, and subsequently, my lord, it was the fifth commission different, my lord, and only sixth pay commission it was merged, my lord. So only this point, my lord, they are not historically there is no priority, and on the basis of that, my lord, this judgment was passed, my lord. So my assumption this may be interpreted, my lord.
Mr. S.K. Medhi, Lanet CGC, as well as Mr. D. Bora, Lanet, counsel for the respondents. CGC for the appellate and also for the respondents. Next part. Aggrieved by the impugned judgment and order dated 22/8/2024, passed by the learned single judge in WPC 6231 of 2013. The present intra-court appeal has been filed. Next one. In the writ petition filed by the respondents, the respondent says assailed the order dated 14/12/2009 issued by the Secretary, Department of Expenditure, Ministry of Finance, Government of India, within bracket respondent number 2. Sorry, appellant number 2 herein. They are not parties here. They are not parties here.
Your Lordship,
The respondent number 2 is not a party here.
respondent, respondent, your Lordship. कौन को respondent party में वो नहीं बता.
এটা তো হয়।
Respondent number 2, your Lordship. Respondent number 2, Ministry of Finance, Department of Western
In
India.
the appeal, they are not parties.
In appeal, okay.
Oh, they are respondent number 58. Okay.
Pro forma
This is,
respondent.
the performer respondent number 58. Within bracket, performer respondent number 38. For thereby granting the benefit of fixation of the merged scale of pay in rupees 7450-11500 with effect from 1/1/2006 in accordance with 6th CPC pay scale of rupees 9300-34800, i.e. rupees 7450 into 1.86 plus 4600 equal to rupees 18,460 to only the assistants oblique PA oblique steno dash C of the Central Secretariat Services within bracket CCS for short, the CSS for short, bracket goes which according to the petitioners were not granted to the field office assistant oblique steno A in the organization like border road organization to which the respondents belong. The respondent was 1 to 27 belong. You copy it from page 26, paragraph 3.1 to page 27, paragraph 3, Roman 5. This you copy. Very good. Next one. The
My lord, my seal will be here, my lord.
the basic facts as stated in the writ petition is not in dispute. For the respondent numbers 1 to 37, they're all serving as assistant oblique steno A oblique private secretary in the Border Road Organization. By an poem dated 25/9/2006, the appearance where the employers, upgraded the pay scale of the assistant oblique steno grade C oblique PA of Central Secretariat Services with effect from 15/9/2006. The said OL is admittedly issued 10 days prior to the constitution of the 6th Central Pay Commission, within brackets CPC for short. The grievances of the respondent numbers 1 to 37 was that they were at par with the Central Secretariat Services all throughout. Though they are posted in field offices. Accordingly, on 29/8/2008, the 6th CPC recommended some structural scale upgradation in respect of field office assistant oblique steno A, make it at par with the secretariat assistant. It is projected that by Gazette notification dated 29/8/2008, the Ministry of Finance had accepted the recommendation made by the 6th CPC. Accordingly, a notification dated 13/11/2009 was issued, by which the persons were in the scale of rupees 6,500 to 10,500 in terms of 5th CPC as on 1/1/2006 were granted grade pay of rupees 4,600 with effect from 1/1/2006. Full stop. Said benefit were granted to those who were in the 5th CPC scale of rupees 6,500 to 10,500 as on 1/1/2006. Accordingly, the grievance of the respondent numbers 1 to 37 is that they have been deprived of such benefit. As per the 6th CPC pay structure, one more pay upgradation was granted to the Secretariat Assistant. But the same benefit was applied to the petitioners. Subsequently, on 14/11/2006, scale placement and session were also granted to the Secretariat UDC small s oblique steno D. According to the respondent number is 137. This created structural disparity between the field office assistant of the steno A and the secretariat assistants, etc. The case of the appellants is to the effect that there was no historical parity between the secretariat employees and the field employees. Since both CPC and accordingly, it is projected that the on facts, the case of the present case was distinguishable from the facts under which the case of capital T stop G stop O stop F Employees Association and another, this is Union of India and others, WBC 4606 of 2013, decided by the Delhi High Court and reported in
Delhi High Court judgment was never reported.
never reported. Decided on 14/10/2014. On the basis of which the writ petition was decided. It is noted that before the learned single judge, it is noted from paragraph 7 of the impugn order, the judgment and order, that before the learned single judge, the learned DSGI had taken a stand that the determination of parity between two sets of employees is required to be done by an expert authority like the Pay Commission and may not be the job of a writ court in exercise of power and the judicial review. Be that as it may, the learned single judge having taken into account the office memorandum dated 25/9/2006, which is the document based on which the present the respondent number is 1 to 37. Also claim discriminated was the same memorandum which was the factory issue in the case of DGOF Employees Association within bracket Supra. The learned single judge also took note of the fact that the decision of the Delhi High Court in the case of DGOF Employees Association within bracket Supra stood affirmed by the Supreme Court of India in the case of Union of India and others versus DGOF Employees Association and others, comma, reported in you said, comma, 2023 INSC 995, comma, reported in Manu MANU oblique SC oblique 1226 oblique 2023. And took a view that the 6th itself had concluded that the parity had long been established. In the present case in hand, as per the office memorandum dated 25/9/2006 under number 20/29/2006 2006. Give a space. What is this number at page 89? 2029/2006, then is it OS2?
CS2,
CS2, okay, CS2. This is Roman 2,
Roman 2.
page 89. The upgradation of pay scale of the assistants and steno grade C within bracket PA of Central Secretariat Services within bracket CCS and service, not services, service, and Central Secretariat Stenographers Service within bracket CSSS bracket close respectively from 5500-175-9000 PO2 rupees 6500-200-10500 was done as an exception specific to assistance of CSS and the steno grade C of CSSS only, and was ordered to take effect from 15/9/2006. From the report on, from the relevant extract of the report of the 6th CPC, which is connects to the memo of appeal. It would be relevant to quote paragraph 3.1.4. It is here separate, huh? Also put 3.1.5 and 3.1.6. This is 3.1.7. And thereafter made the recommendation for a pay scale of rupees 6500-10500 with pay band 2 and grade pay of rupees 4200. The said recommendation has been extracted in paragraph 18 of the impugned judgment and order, and therefore, is not reiterated in this order. Moreover, next paragraph, moreover, as per paragraph 7.39.24, I put you. The sixth CPC took note of the fact that the administrative cadre has demanded higher pay scale on par with those existing in the secretariat, and that the commission had already recommended parity between similarly placed posts in headquarter organization and field offices in chapter 3.1 of the report, made recommendations to be extended to the extent EXTA and extent case as well. Thus, the court is inclined to concur with the finding of the learned single judge that there is no doubt that parity existed between the CSS employee and others in field offices, including the petitioners. The said parity was sought to be disturbed on the basis of the office memorandum dated 25/9/2006. The authorities appear to have missed the sight of the fact that while OM dated 25/9/2006 the upgradation of the pay scale was to take effect from 15/9/2006 and not from 1/1/2026 as indicated in the office memorandum dated 16/11/2009 bearing F number 1/1/2008-IC issued by the Ministry of India, Government of India, Ministry of Finance, Department of Expenditure, implementation cell. Thus, the finding of the learned single judge that the disparity was aggravated with the OM dated 25/9/2006, which was the starting point of discrimination. Next. Moreover, as the issue arising out of the said OM dated 25/9/2006 was the subject matter before the Delhi High Court in the case of DGOF Employees Association and another within bracket Supra. And the decision of the Delhi High Court was affirmed by the Supreme Court of India in the case of DGOF Employees Association and others within bracket Supra. There's no reason to take a view different from one taken by the learned single judge. Accordingly, the court does not find any merit in the petition and the same is dismissed. Negative is dismissed. Next panel. The parties are left to bear their own cost.
Highly operational.
Is there any interim order operating?
No one.
What is this two? There are two matters.
Yes, so much of them.
Item number 2,
My lord, the common
common judgment.
The judgment in both the cases are common.
Common.
Then we'll have to write in the first paragraph. The common judgment passed by this court in so and so. Sorry, in WPC 6231 of 2013 and WPC 7209 of 13. I said only one. Huh? There are two repetitions decided by common judgment.
Daily list item 4 for orders.
May I please, Your Lordship? Lordship, this IA for condonation of 240 days delay in preparing the Lordship connected appeal, writ appeal. The order was passed on Lordship on 14/3/2024, Lordship.
So the order of the learned single judge
Yes, Lordship.
maybe says that the direction was only to determine the claim and release the bill. What is wrong in that?
Lordship, but our stand is that, Lordship, the issue was whether the price variation clause is applicable to the tender value or the contract value. As per the learned single judge, Lordship, it is applicable to the tender value, whereas our stand is that it is applicable to the contract value. As per the order, Lordship, tender value above 5 crore, Lordship, PVC applicable, but as per the policy decision, Lordship, in contract value less than 5 crore, the PVC is not applicable. Here, the petitioner, Lordship, here in respondent's case, Lordship, the tender value was above 5 crore, but the contract value was 4 crore or something, Lordship, below 5 crore.
The copy of retail was not served to me, ma'am. Not so, only for condonation of delay petition has been served.
Lordship, whatever, Lordship, the tender was issued on 13/12/2019 for construction of some double-storied quarter of the railway in Borpeta and Bongaigaon, Lordship, and tender value was
Just a moment.
Lordship.
Then we'll not go into merit. We'll
Lordship,
restrict ourselves to this confirmation application. Now, please tell us, the respondent have taken a stand
Lordship.
that this appeal was filed only after contempt was initiated. Is it right?
Yes, Lordship.
Then where is the
Lordship, delay has been explained in para 345 onwards, Lordship. The consent of different Lordship departments, different divisions is required, Lordship. Therefore, some delay has caused in filing the appeal.
9 months delay?
9 months delay, Lordship. Since there was some maintenance work of the Lordship, railway line was also going on. So in this process, some delay has caused, and later on, some delay has caused also from my part, Lordship. There was a surgery of my surgery, Lordship, and I was out of state. Therefore, some delay has caused also from my part. Yes, Lordship. Yes, Lordship. Yes. Lordship. Yes, these are the office note, Lordship. Yes. There's an office note, Lordship, forwarded to the authorities for consideration, Lordship, and Lordship. No, no, Lordship. After, in consideration of all this, Lordship, on Lordship, it may be heard on merit, Lordship. Lordship, these are the office notes of by different authorities, Lordship. In consideration of this OS construction, repetition. And in consideration of this office note, Lordship, the authority has passed the impugn order rejecting his claim for Lordship. Yes. No, Lordship. since it is an internal communication lordship, the final order is issued in the these are internal note. I don't really know how they have received this lordship. This is a part of their repetition lordship. Yes, lordship. Lordship, our case is at page, lordship, 83, lordship. Lordship, page 83. As per the circular, lordship, earlier it was, lordship, on tender value, the PVC.
Council, you were saying this is an internal memo,
Lordship,
but this is not an opinion
lordship.
that has been given by a certain officer, which may or may not be accepted by the higher authority. This is simply a finding of fact that it has been incorporated. So what is there to accept or reject? It has already been incorporated.
This is internal communication. Someone has lordship stated that it should be. No, it is. It was lordship in their repetition. Therefore, it was annexed lordship.
They never denied it, my lord, respect. They never denied it, my lord. That's fine. That's fine.
But there is no question of denying lordship. This is, since it is an office note, we cannot deny it lordship. And ultimately, the final order has been passed, which is under challenge, which was under challenge in the repetition lordship.
You cannot deny it, and we deny it.
No, sir. Lordship, I may be allowed, and it may be decided on, it may be fixed on lordship, the Thursday lordship for final hearing lordship. It may be, next week, it may be taken up for consideration on merit lordship. I may be allowed at next days.
Humble submission before. That's fine. That's fine. Because, my lord, contempt order has been passed, my lord. Thereafter, they are appearing before the court, my lord. And interesting thing is that, my lord, I am normally not saying all these things. They are not mentioning what period the council is not well. And yes,
In November, I have,
my lord.
I have the records,
In the
medical
meantime,
records.
that period, my lord, they are appearing in the contempt case, my lord.
No, lordship, I have
on every
medical reports, lordship. I will
every document is available. In the meantime, they appear. Your lordship can. That is why I am submitting before the lordship. That normally I am not. But how can they appear before the contempt case, my lord? In the meantime, my lord, contempt case they have appeared, my lord. That is the important thing. Normally I never made this objection, and they are not mentioned the period.
Lordship, before 20, maybe fix lordship, because I have to go out of station, lordship, for my brother's treatment, lordship. His treatment is going on in Kolkata.
Right, okay.
Item 1 with item 2 for admission.
Well, discussion will be kind of taken up after some time, I don't, 1 and 2. 1 and 2, yes, most of the procedure will later, she is coming, my lord.
But my lord, in this case, BC Chaudhary is not appearing since long back, lordship. Who is the petitioner in this case? The petitioner.
It's okay.
Last occasion, lordship segregated
It's
the all
okay.
the matter.
It's not that they will see, but wait for some time as.
Item 3 for orders.
Yes.
My lord,
You are there. Do you have the information about, you have seen the last order?
yes, my lord, on the basis of that, my lord, we have filed the affidavit.
Last one.
Lordship may kindly see the affidavit at page 401. my lord. The affidavit. 401, it start from 402.
If you see, so far as serial number 1 is concerned,
My lord,
that's okay. The constable has been deputed.
my lord,
Now serial number 2,
my lord.
serial number 2, you say that the amount of 424,860 was paid.
Yes,
And then for the proposal of 349 is being processed. But what about the vehicle? Is it there or withdrawn? That you don't say anything.
regarding vehicle, my lord. My lord. My lord, before my lord, starting my lord, I have just now, my lord, handed over the brief because my lord, this case is handling by my senior colleague, Mr. Dilip Mazumdar, is out of station today, my lord. I will try to, my lord, assist your lordship, but I'm not well prepared. My lord.
And one compilation, my lord, report of
Journals, my lord, they are 2026, they are not continuing. 2000 journals, serial number 3, 2026, they are not. Yes, yes, my lord. But this has not happened as of, yes. Fine, fine. Look, this serial number 4 is important, my lord, because they have furnished one compilation. Lordship will have a look of that compilation. In some of the courts, the ASLAS is not there. In fact, the very first one, that is Borpeta. Compilation.
the compilation report soft copy has been emailed, my lord, as stated by my colleague, Mr. Nayak. This is the hard copy, my lord. What is your?
মানে এই যোনটো কম্পাইলেশ্যন আছে সেই তাৰে এই কম্পাইলেশ্যনটো 4 হিচাপতে বনোৱা গৈছেতো এই বৰপেটাত যোনখন মানে ফৰ এক্সাম্পল যদি বৰপেটা চাওঁ হা কোৰ্ট ৰুম ইজ এজলাছ ৰিকুৱাৰ্ড এজলাছ নাই কোৰ্ট ৰুম মানে বৰপেটা নট অনলি বৰপেটা ইন অল দ্য এখনিখন ৰিকুৱাৰ্ড এখনি এভেইলেবল ৰিকুৱাৰ্ড সেকশ্যন য়েছ চবতে Yes, চবতে লাগে তাৰমানে খালি লাগেই লাগে yes মানে এভেইলেবল একোৱে নাই হয়
ইয়াতে কিবা question ಇದೆ ಯಾಕೆ ಇದೆ ಶೇಷ?
Page number 8 of town. Page number 8 of. 8 to
Infrastructure structures for Mr. Borpeta. Subject requirement to the establishment of bank for the court office. Lordship, may kindly go to the page number 8, my lord. Regarding Borpeta, ma'am.
You see, come to page 17, we are just taking at random
My lord.
because you've seen it for the first time. Come to page 17. Room with Ejlas not available since inception.
My lord.
Chamber not available. Space for government feeder not available. Record room not available. Washroom facility for member not available. Court diary not available. Due to non-financial sanctions since 2025-26. You don't even give a what you call the court diary.
That's true. But what, my lord, joint inspection said, we have to go through that, my lord. There is a report of the joint inspection as a, physical inspection says 414, my lord, of the affidavit. 414. What does it say, my lord?
This is not joint. We passed an order. This committee says that now call for the reports and compile it.
Right.
So this is the compilation.
This is the compilation.
There was no joint inspection. We'll put it on record that we give you 1 month to take a decision. If you don't start repair works, then functioning of those tribunals which are in inhuman condition, those functioning will be stopped without prejudice, without stopping the salary of any of the staff engaged in the foreigners tribunals. Functioning of these tribunals will stop.
Sometime may kindly be given.
We'll give you this month. You have to take a decision, take it.
My lord, some more time because of the forthcoming, my lord, election.
That is the problem of the state. We can't stop the judicial dispensation
That's true, my
system.
lord. That's true, but, so far, if my lord, election comes, my lord,
No,
Officers-
we are giving you absolute freedom.
my lord.
Why do you need foreigners tribunal to function during the election period? What is such a hurry to send out to detect foreigners? No constitutional mandate.
That's true, my lord. But since, my lord, this period, my lord, 1 month.
You don't take a decision, it's your call. But first, the next date when we are taking up the matter, all these foreigners tribunal which are not in an appropriate condition.
My
we'll
humble
make that
submission
assessment
is
then.
your lordship, we have 2 months' time, my lord, that perhaps.
For decision? No,
Not
no.
for decision, my lord.
Repair work is something
work.
else. Unless you take a decision, your repair work won't start.
But lordship is giving time for decision, 1 month for the decision.
Yes, because this is compilation has been made. You take a
Yes.
decision within the
That,
next
that,
working
that,
date.
that can be done.
And we are making a note in the order sheet
Right.
that if the decision doesn't come, then functioning of those tribunals which are in pitiable condition, those functioning will stop.
No, honestly speaking, I also did not expect this, my lord. I also was of the bona fide view that there is something. After
No, you
seeing this
see-
report, my lord, it's really very shocking. My lord. It's really very shocking.
That's why we called for that report. Small things were coming up and then
Exactly. No, that's the correct thing, my lord. That has happened. Item wise, because
and can the state also finance department take a decision? Page 17 you are having,
It's 70.
17
70.
that you were having.
17.
financial sanction.
This cash book register is not available due to non-sanctioning of, non-sanctioning. So can we make an observation if you don't provide the, cash book? There will be, what you call this, people who are working in this office, they will never be held accountable for any financial irregularity.
Lordship, without any observation, Lordship making one time as proposed your Lordship. Perhaps, my lord, since my lord,
No,
things are
no, no,
moving, my
you see,
lord,
these are
things are
creating,
moving.
these are creating administrative problems for us.
My lord.
Not only, as a single judge, I am taking up this administrative matter for the functioning of the tribunal. That is being done because of the directions contained in the orders of the Supreme Court in Sarvan Songo that it should be monitored
Yes, my lord.
by the High Court. So we are doing that monitoring. Incidentally, I am also right now presiding the bench, taking up the foreigners tribunal matter. Now, you know the difficulty in getting the records. There are some people who have been taken into custody. They are praying for bail. We want to look at the records. Now the calling up for the records takes a lot of time. We'll have to send a requisition. So what we have started doing is that we have started making the requisition through email. Now, because there is no computer, the foreigners tribunal in Golaghat does not have an email. You want to see the list? We are maintaining everything. Just because the state is not providing, we have to do that. Give that list. The email address.
Since your Lordship taking up the foreigners matter for a long time, my lord.
No, but you see the difference, the difficulty. How we will call the records?
Right.
We'll have to send requisition by post and wait for years together for the notice to be served. Show it to him. Except for these tribunals, the other tribunals don't even have an email. How to send the requisition? Now, in the age of when we are talking of computers and AI on everything, we don't have even an email address for the tribunals. How do you expect us to look at the records? It should have been online by now. You see, there are, how many tribunals are there? How many tribunals are there?
100.
100. Out of that 100 in these 2 pages, 100 are not there.
Yes.
So therefore, there is a shortfall even in the email addresses. Consider look at this to show that there is no ink, there is no cartridge.
I think, my lord, 50, 60 numbers in the list.
You know what is more surprising? In one of the proceedings, not one, in maybe 40, 50 proceedings, we found the certified copy to be handwritten. We thought that you were not providing stenographers. We made an inquiry, and in the inquiry it came that the officer has everything, but she just wants the copying section to write the certified copy. So in the age when we have photostats, when we have everything, now there is one presiding officer who is torturing the staff by making the copying assistant write by hand, and that handwriting is wonderful. One of the best handwriting I have seen in my I've seen of anyone. It's absolutely impeccable handwriting. Every letter can be measured in millimeter and centimeter. You will find same size. There can't be a beautiful handwriting than like more than that.
It may be difficult for read my.
That beauty had become a difficulty for that person.
Huh?
That beautiful handwriting had become a difficulty for that person, my lord. And
It
major
cannot be expected, my lord, the handwriting, all our persons handwriting are.
possible.
No, but
It's not
the
possible.
problem is that if you don't provide, what to do?
Understood, my lord.
You see, of the just one more page, 66. I'm just taking from random. 66. Yes, now washroom for member is nil, the washroom facility for staff is nil, washroom for litigants is 1. So litigants are at a better footing than the presiding officer of the tribunal. At least they have a urinal. Now, look at the requirement next, eraser 1. So even for a eraser, the tribunal has to write to the High Court that we don't have a eraser. Punching machine. If these are the requirements which are coming to the High Court, am I wrong in saying that disband these tribunals?
No, not at all. Extremely sorry, state of affairs. Extremely sorry.
But
No, what,
thus, we're giving them this month's time.
Yes, ma'am.
Next,
Since my
next
lord,
will
your-
be,
Because there cannot be any words to explain the situation, my lord. But they'll have to, it's not that they are required to do this now. For last 10 years, this should have been done and in a proper, something somewhere is missing,
something is wrong.
something very wrong, my lord.
Since my lord, everything has now, my lord, come to the light, my lord, the problem may be solved at the earliest, my lord.
Let us hope so.
My lord,
That is why I'm indicating in the order itself.
my lord. Everything has come out from the, my lord,
We
compilation.
want to have an insurance also. Next will be taking up on 2nd of April.
Right.
Second of
Third,
April.
Mr. H.K. Das,
Yes.
the standing counsel for this court, as well as Mr. A. Das, learned. Mike is
Yes.
Next, para. Not expert, also heard Mr. D. Sharma, learned additional senior government advocate, along with Ms. I'm extremely sorry. Maybe learned, the government advocate, and Mr. R.K.D. Chaudhary, learned DSGI for the Union of India. I'm extremely sorry. I always forget. I don't know why.
Sometimes happens, my lord.
No, not sometimes. It happens with her every time. You can only excuse me by thinking that he's an old man. Pursuant to order dated 3/2/2026, the state has filed an affidavit. The state respondent numbers 1, 2, and 3 has filed an affidavit. Response of the said respondents in tabular form, which is made in paragraph 3 thereof, is extracted herein below, page 402. 406. Mr. Sharma, can you give us this in a soft copy also?
My lord.
Can you give us this affidavit in soft copy, because we'll be copying this page 402 to 404.
My lord, I'll give.
Soft copy of this. Give it to the court master at the address. Next para. In respect of the physical inspection of the foreigners tribunals, the Political B Department, Government of Assam, by letter dated 5/2/2026, had asked all the district commissioners of the co-district commissioners in the state of Assam to nominate a representative for carrying out physical inspection of the foreigners tribunals under their jurisdiction on or before 12/2/2026. So the court is awaiting the joint inspection report as indicated in this letter dated 5/2/2026. Next paragraph. In the meantime, as as per directions contained in the order dated 6/1/2026, comma, these are, Mr. Das, these are all 100.
Sorry, my lord.
All, this is a compilation of all 100.
I haven't checked. Excellent, excellent. Border.
We will not know because
My lord, a list they have given, my lord, one list.
no list is at page that's 29. There is 29 districts,
Yes, 29 districts.
but is it for all the foreigners tribunals? For
Yes.
example, Borpeta there is 10.
Down below, there are 100
numbers, my.
100 numbers.
So we understand, but
Yes.
serial number 1 is Borpeta 10. Do we have all the 10 Borpeta reports?
That, yes, my lord, there are, just check, my lord, at least for once.
100
One.
tribunals functioning in 29 districts. And the respective foreigners tribunals
Five.
have provided the details of infrastructure available in the respective foreigners tribunal as per the format provided. Full stop. On principle of the same,
Is there, my lord. It's
comma,
there.
except for very few tribunals, comma, the reports depict very pathetic condition of several of the tribunals. Stop. Some of the tribunals lack the courtroom and ejdlas. Several of the tribunals do not have a separate washroom for the learned members and the staff of the tribunal. So the conditions of the furnitures in most of the tribunals is in very poor condition. So in some tribunals, a bare minimum requirement of small items like eraser, cash book, and court diary is also not available. Next, therefore, comma, as paid for by the learned additional senior government advocate, the court is inclined to grant some time to the state to examine the infrastructure conditions of all the 100 tribunals. This has been forwarded to you, or which has been forwarded to the learned additional senior government advocate by email. It is hoped that the appropriate authorities in the state government will take an urgent decision regarding the infrastructure requirements of all the foreigners tribunals and take immediate steps for making the infrastructure available in the tribunals for efficacious dispensation of justice. Next para. The status put to notice that if basic infrastructure requirements of an appropriate courtroom with ejdlas, washroom facilities for member and washroom facility for staff, and for essential furnitures like chair and table are not made available, the court would be compelled. No, the state should file an affidavit to inform the court as to how they desire the tribunals to function without essential requirements, and to also inform as to why the functioning of those tribunals where the infrastructure requirement is not met should not be given a long-term holiday, paid holiday, till the appropriate infrastructure is created. Next paragraph. We request the learned additional senior government advocate to send the downloaded copy of this order to the two letters we have received regarding Chief Secretary to the Government of Assam, Home and Political, within bracket B, bracket close, Department, with liberty to both the authorities to send this the copy of these orders to all the district commissioners, the state PWD, and to the PWD with the packet buildings, Department. of all the districts as well as to the finance department of the state of Assam. Not so comma to examine the infrastructure requirement to take appropriate steps. And on the next date of listing, comma, the home and political within bracket B, bracket close department, after consultation with the state PWD and the finance department, shall file an affidavit as to the steps which are proposed to be taken, and to also inform the timeline within which all the foreigners traveling in the state of Assam would have the requisite bare minimum infrastructure for effective disposition of justice. Next one, list on 2/4/2026
At 2 p.m. Malik.
preferably at 2 p.m.
Look, we received 2 letters. Lordship will kindly have a look. This is with regard to withdrawing of security arrangement from 2 foreigners tribunal members.
At the registry of this court to the standing counsel for this court has produced copy of letters received from the member, foreigners tribunal Udalguri, regarding withdrawal of security personnel, and similarly by the members, the learned member, foreigners tribunal 9th Nagaon, regarding engagement of PSO to other duties.
So far, Dorong, Mongoldoy and Udalguri, my lord, lady constable are redeputed, my lord, as per the.
No, this is new.
This is
From
new.
Nagaon Sadar,
My lord.
and one is from Udalguri.
Udalguri, my lord, it is redeputed. Okay,
No, it's a note.
my lord.
So the learned standing counsel for the High Court shall provide a photocopy of the said 2 letters to the learned additional senior government advocate. Next paragraph. As it has come for the second time during the recent sitting of this court regarding withdrawal of PSOs of the learned members of the foreigners tribunal, let a copy of this order be also, we request the learned additional senior government advocate to also transmit a copy of this order to the Director General of Police, Assam, and to the Home and Political Department, Government of Assam, so that the authorities in the Home and Political Department, Government of Assam, and the Director General of Police would take a decision regarding availability of making available the PSOs to all the members of the foreigners tribunals in the state of Assam, and to file an affidavit to that effect to a officer not less than the rank of Joint Secretary of the Government of Assam, Home and Political Department, by the next state of this thing. Now, you are happy to.
Much obliged. I'll furnish a copy. ma'am.
One set of those letters are written on.
Yes, my lord. Originals I'll please, I'll give the photocopy. my lord. Yes, obliged. I'll.
Mr. Chaudhary, you wanted to say something? No. But from your, for our interest, oh, you are also there? No, that's for the interest of the, of these tribunals, can we make an attempt to find out? Because we told you last time also, few sittings before that also. Because for furnace tribunals, the funding is from the government of Assam, the union government. Now, is there any bottleneck so far as the union and state is concerned? Just make a note because you are not putting that in the order. So this compilation is made up of.
Highly obliged. Much obliged.
Time being item 1 with item 2.
Lordship, I am appearing for the state. We prefer the review, Lordship. But difficulty is that, Lordship, I have been asked to appear just 10 minutes back. Before two, Lordship.
No, not that.
Hmm.
You see, this opportunity is given only to those who are brilliant.
No, Lordship.
And there's nothing, you see, what has happened here.
Lordship.
You have seen the order.
No, actually petition and
Okay. You see, in this case, what has happened in your review application,
Yes,
what has
Lordship.
happened was that we found the petitioner to be entitled to the
Compensation part.
No, to be appointed,
Huh. That has been complied, Lordship.
but she has been deprived.
Lordship.
And therefore we said that
to pay the compensation.
because the appointments are already made with not without adhering to 3% reservation, and therefore she was deprived. We directed to you to pay a compensation of rupees 4 lakh.
Lordship.
So what is so wrong about this?
Nothing wrong, Lordship, but one thing that the reason why it took time, Lordship, this could not be brought before your Lordship, because the concerned official, the CDPO, she was engaged in NRC duty, Lordship. This is there. So because of this, as she was out away from her station, Lordship, and he or she could not discharge the duty properly in that particular point of time. So there was delay, Lordship. So this is only
That's
humble
only-
prayer
There's only the question of delay.
to delay and the fact to be brought before your Lordship before passing the order. This is lack on our part, Lordship.
That's okay. But what is the lapse? Tell us what is.
So that's why this is a humble prayer before your Lordship to reconsider this one compensation part only. Only that much, Lord.
No, if one is deprived, how will you compensate? We are following the public law remedy.
Lordship.
So please tell us how would you avoid if somebody is found entitled to? You see, the difficulty is that somebody is drawing a salary.
Lordship.
Do you want us to state to say that instead of compensation, pay for the salary which you have drawn? Would you like it to pay salary to 2 persons instead of one who is working? How would you compensate this person who is otherwise entitled to an employment?
Lordship, can I pray, Lordship? My prayers, if your lordship kindly, because only just here only at 2 o'clock went through the brief lordship. If your lordship kindly allow a week time lordship so that I can,
But number two, state number one is not there.
Yes.
yes.
On last occasion also 19/5, 2025, 26 lordship.
Item number one.
25. 25
Item
lordship.
number one say,
Order passed by decision number
none
4.
appears for the petitioner on call. However, Ms. S.K. Nargis, counsel for the respondent number 7 and
I'm appearing in this case for respondent number 4 actually, which is a typographical mistake, my lord, in petition 4617, my lord. No, I don't. Yes, yes. Four, my lord, total 4
Okay,
respondents,
four, not 7, 4.
typographical mistakes. Okay. Petition, no? And let me become.
Ken Bhattacharya. For the state, respondent numbers 1, 2, and 3 are present. The petitioner had remained unrepresented. The letter was previously listed on 19/9/2019, 19/9/2025. Accordingly, it was observed in the order dated 19/9/2025 that if the petitioner remains absent on call on the next date of listing, adverse orders will follow. Next paragraph. As the petitioner remains unrepresented, this petition stands dismissed for non-prosecution. Item 2 is say both sides are represented on the prayer made by Ms. M. Bhattacharya, that is the magistrate is on today.
Thank you.
List on the date. Nineteen three 2026.
19 March.
Yes,
And
item
deeply
4.
Obliged, lord.
Item 4.
May I please, your lordship?
Yes.
Lordship, we could not procure any alternate address for respondent number 3, your lordship. Service.
Can I ask you a difficult question?
Your lordship.
Yes or no? Yes. You seem to be young, that's why I'm asking you. You use social media?
Yes, your lordship.
Yes. Can you take out your mobile? And type HDFC Chubb General Insurance Company office at Gauhati. Got it? Very difficult. Then your case is pending for 2018.
Yes, Your Lordship.
Should we strike out the name of respondent number 3?
A short date may be given, Your Lordship, kindly. 1 week.
Don't allow old man to be smarter than you. You should be more smart when it comes to all this gadgets and all. And with that statement, you cut a sorry figure. Don't do it. And nothing is when we have Google to search out every address, every nook and corner of the world. Finding out an office is not very tough. Both sides, the petitioner and the petitioner and the respondent number 1 are represented. To stop. The learned counsel for the petitioner had stated that she could not trace out the address of respondent number 3. To stop. On being prompted by the court, the learned counsel for the petitioner could ascertain the address of respondent number 3 in her mobile. To stop. Accordingly, she praised for and is granted a week's time to take appropriate steps for service of for filing an affidavit to bring to file an interrogatory application to bring on record the correct complete the respondent number 3 with correct nomenclature and address. To stop. Next para, it is made clear that if appropriate steps are not taken within a week from today, adverse orders will be passed on the next date of listing. Next para, list of 19/3/2026.
Much obligation.
Item 5.
Lordship, please, if the matter can be kindly accommodated for today.
This petition is a totally misuse of the process of the court. Misuse of the process of the court, my lord, your lordship can see page 58. And because of this, my lord, tendency of the case, they are unable to draw up the decree.
But what is the reason why you're not wanting to do it today?
Page 58.
Indeed, counsel, Mr. Purkashta, like due to he had some personal difficulty, so he could not be fully prepared with the case facts. So he
No, then you should have separate. You see, when a senior counsel is appearing in the other side, you should have the courtesy to inform him he has been sitting in the court.
No, this is because of the tendency of the case. My lord, your lordship will kindly see page 58, madam.
58.
58, this is an order on the basis of the mediation order. If the respondent number 1 is mentally challenged, a person and therefore the respondent who has both learned counsel while referring to state medical mediation agreement, the learned counsel for both sides have expressed their immense appreciation for the mediator, namely Sri so and so, submitting that the parties and their respective learned counsel have already lost hope. In view of the last page, settlement dispute, it is provided in the learned trial court, civil judge not less than court shall record the settlement in the suit and shall draw up decree. Then thereafter, my lord, they have filed this review petition, and because of the tendency of the review petition, that they are unable to draw up the decree. After mediation, my lord, they have filed a review petition and also a condemnation petition, delay of 2000 some days.
No, have you stayed it?
No, but even then, when the court gives us that they are not doing it. Even then, my lord, court gives they are not doing. Suit has been dismissed. Suit was filed by them. The injunction was not granted. Injunction was granted. Against the order of injunction, we came and filed a revision petition here, and out of that, my lord, the mediation in proceedings arose. Ultimately, suit was also dismissed in 21. The civil court, civil judge is also not taking any action.
Okay. We will clarify that. Your name?
T.N. Bora. T.N. Bora.
K.
T.N. Bora.
T. Bora.
T.N. Bora.
T. M. Bora.
C for Chiranjeev.
Okay. CM Bora, run it. Counsel for the applicant. Appearing on behalf of Mr. A.K. Pulkastal and counsel for the applicants has prayed for an adjournment. Next, the prayer for adjournment is proposed by Mr. B.D. Das, Learned Senior Counsel, assisted by Ms. R. Dekar, Learned Counsel for the respondent. Applicants. The respondents. First of it is submitted that merely because of the pendency of this interlocutory application, which is filed under Section 5 of the Limitation Act, with a prayer to condone the delay of 270 days in preparing the review connected
2000,
review petition.
2,211 days.
See the cost title here, it is 270 days.
The petition, it has been written, and down below, I mean, some correction is there. It is 2,200.
Where is
The
it?
order was passed on 13/9/2018. Review filed in the year 2019. IA filed in the year 2020. Delay contribution. So totally it comes to 2,211 days.
No, just a moment.
What happened? What difference is it? Now, for the timing, let it be there, otherwise
Just a
I'm
moment.
giving the dates.
Just a moment, I'm concluding. No, it will be 270 days only. The calculation is there. The opinion is, the order is of 13/9/18.
18 days, Nanda.
The, this review petition was filed on 17/6/19.
17/9, yes,
17/6/19, so time stops then.
and then after,
Filing of the delayed, filing of the review application, condemnation application would not matter.
well, I leave it.
270, on the ground that the below 70 days has been paid. It is submitted that merely because of that, comma, the learned mediation act, which is the designation of the trial court,
Civil judge, Lakhimpur.
civil judge within bracket senior division, bracket close, Lakhimpur, has not complied with the direction of this court contained in order dated 13/9/2018, passed in FAO 29 of 2018, by which the said appeal was disposed of in terms of the agreement for settlement dated 10/9/2018. We made a part of record and marked with letter X.
In IA 2476/2018, page 56.
Similar order. Common order. It's not the common order. We have 39 expenses passed in FAO 29. As well as in IA Civil 2476 of 2018. Next paragraph. Having noted that this application for condonation of delay is pending for last several years, while allowing the prayer for adjournment, it is clarified that as the review petition has not been taken up and the delay in this interlocutory application has not been condoned, there is no prohibition on part of the learned civil judge Lokhimpur to comply with the common order passed by this common order 39 2018 passed by this court in FAO 29 of 2018 and IA Civil 2476 of 2018. Next, the respondent is at liberty to produce a certified copy of this order before the learned trial court. Next paragraph, list on 19/3/2020.
19(3),
And we are giving you liberty.
Yes, yes. Otherwise, as per the provision of this Mediation Act, review can be only because of the fraud and corruption, not because of anything else.
But we are giving you liberty.
All right.
Item 6.
Yes.
May it please your lordship. My senior learned counsel is engaged in another court and court number 9 lecture. So please, can you kindly? It says no.
Review petition.
One is having his petition. 6 hours, no? Sorry. My lordship, I'm sorry.
There has been a mistake, my lord. It is
Yeah.
my matter.
It is a divisionment's matter.
Oh, ours is division means,
Yes.
oh. Yeah.
So this review can't be permissible. It is for you to take a decision to fix a pay and then give the necessary action. In our orders, we have not said, give him the pay scale of so and so. We said in the order,
In
fixing
the
his pay scale.
order, my lord had said that he's entitled to pension, my lord.
Pension. So therefore, you pay your pension. What is the accounting principle to be followed that you know?
That is the thing, my lord. That principle applies to already regularized employees. But in this case, my lord, this petitioner was not regularized, my lord. So
Then appeal. We can't be here on merit. That was for you to say on that time, not now. It's not a case of review, it's a case of appeal. It's an erroneous decision.
but that is one, my lord, only on that point, my lord.
That's an
that-
erroneous decision. We have the red petition. Did you file a affidavit in that case telling us all those things?
In that petition, my lord, we did not file it because at that time, my lord, it was not brought to our notice that he was not regularized. Only later, my lord, we came to know. We have annexed the communication also, my lord. In page 17 of our review petition, the pension papers were, my lord, returned by accountant general.
You see, that is something else. You know what has happened in the red petition? You're aware of what has happened in the red petition?
Review petition, my lord.
You file an affidavit. In that affidavit, you say that the petitioner's service, the service of the petitioner was terminated. I don't remember the date. After that termination, on a particular date, after that, a certificate is issued by your officer stating that this is a certificate of engagement with effect from 15/10/1988 to 22 through 1995. You say that it is a forced one. Correct? This was on the basis of your personal knowledge. You say it is a forced one. Now, how can, by looking at a document, you say it is a forced one? Did you make an inquiry? Then you take a U-turn in the same affidavit. Then you say this certificate was made by an officer of the rank of assistant executive engineer. That is not acceptable. Can you take that stand together? If it is forced, it does not have the signature of the officer. If it has the signature of the officer, then it is not forced. Can you take this two contrary stand together?
That is on my.
Now, the second is that even post, maybe this officer is retired. Have you taken up disciplinary action against him, stopping of his pension and others? Did you do it for giving a certificate which is not entitled to issue? Have you produced any document before us saying that the assistant executive engineer cannot give any certificate?
One thing, my lord, that definitely, my lord, in that proceeding, not
everything was placed on our part, my lord. That is a complete lapse on our part, my lord. That is why we thought review is the correct way. Because ultimately, my lord, application of this case, Sandita Roy, will only apply if he was already regularized. Here, my lord, it is
It will
the
also
must.
apply if you don't regularize, illegally kick out someone, principle of Sandita Roy would be followed.
Because, my lord, as per Upendas, they get minimum pay scale as long as, my lord, they are in service. After that, my lord, they are not entitled to pensionary benefits. My lord.
And this, then it's an erroneous decision. If you don't need anything, can that the decision be said to be erroneous? That is the second question. And can we review it on that ground? You can't say as a government, I did not have the papers with despite due diligence.
That is, my lord, but we are, my lord, trying to get away, my lord.
These are very, what you call, people of very marginalized class. But Style article counsel for the petitioner. This is an application for review of the order dated 11/12/2020, passed by this court in WPC 7022 of 2015. Next one. By virtue of the order under review dated, the order dated 11/12/2020 under review, next paragraph. The effective part. No, it is not effective. You say that this court on examination of the materials available on record took cognizance of the fact that the case of the petitioner was that he was employed as a muster roll worker till September 1990, and he was verbally terminated in the month of September 1990. However, not the petitioner, the respondent hearing, respondent number 1 hearing. The respondent number 1 further projected that he was appointed as a work charge section assistant by order dated 22/2/1995, and he was rendering service at the Hojai division of PHE, where he was working in the said post till date. In this regard, the learned counsel for respondent number 1 had referred to the office order numbers 166 dated 22/2/1995 and statement of GPF account, which was annexed as Annexure 10 to the writ petition, to show that he had a credit of GPF for the month of December 1997 onwards till March 2003. The next paragraph. This court had recorded that it was not disputed at the bar that the case of the petitioner was forwarded by the PHE department for regularization of service. Accordingly, comma, This court had held that even if the appointment with effect from 15/10/1988 was not considered, but the respondent number one had been able to show a prima facie case for his appointment as muster roll worker with effect from 22/2/1995. And accordingly, this court had taken cognizance of the service rendered by the respondent number one as a muster roll worker under Hojai division with effect from 22/2/1995. Accordingly, in light of the ratio laid down in the case of Sanjita Roy versus State of Assam and others, WPC 1089 of 2015, decided by the common order dated 4/12/2018, the respondent number one was found entitled to be extended the benefit of pension and other pensionary benefits. However, further providing that such benefit would operate prospectively with effect from 4/12/2018, on the date when the case of Sanjita Roy within bracket Supra bracket close was decided. Next. Supporting the prayer for review, the learned standing for the applicant, for the review petitioners, has submitted that the pension papers sent to the Office of the Accountant General for fixation of pension of the respondent number one was returned back by a letter dated 5/10/2021 by the senior accounts officer and accounts officer, Office of the Accountant General within bracket ANE bracket close Assam, along with the service book of the petitioner of the respondent number one to the chief engineer of PHE department with a request to re-examine the fixation of pay and resubmit the same after correction of pay from 1/1/2006 till the date of his retirement. It is the contention of the petitioners that the primary objection was on the ground that the service of the petitioner had never been regularized, thus, making him ineligible to receive the pension. Next one. Only, it is submitted that in view of above, the case of the petitioner, the respondent number one could not be considered for regularization. Moreover, it is submitted that as the service of the respondent number one was not regularized from the decision in the case of Sanjita Roy within bracket Supra, not apply on the applicant as respondent number one. Next one.
I mean, this, one judgment, if I may.
Yes. Next para. Yes.
Similar grounds, my lord, review was allowed.
So here they did not work for that amount of time.
Yes.
Here we have given a positive finding that they have, even from 20, what do you call that? 2020, no, what is the date? 1995. He has completed more than 25 years of service. How do you get the GPF entry then?
Even then, my lord, Upenda's judgment has been referred here, that as a concession, minimum pay was awarded to them. And those who were already, my lord,
Please
regularized,
tell me, is this category of persons covered by Upendas? They have a GPF account.
GPF account, my lord, the officers, division officers, my lord, they can open it. Later on, if there is an object by,
Without having a permanent service, it can be opened. Can you give a statement from the secretary to the PHE stating that? PHE is headed by Chief Secretary,
special chief secretary,
Additional Chief Secretary,
special chief secretary.
Special Secretary.
There is
Can
a-
you ask him to file an affidavit that GPF account can be opened?
it was erroneously done, my lord, if done, that.
No, don't
that
change
is-
it.
That is why
Don't change this hand. If it was erroneously done, have you brought in anything on record that it has been done? Do you take steps for termination of service of those persons who have created GPF account illegally? You pamper all the wrong persons. Those who, what do you call, take out money from the exchequer, you give them awards. And this is a poor fellow who is only this casual worker. You went out all your anger on them.
that is, my lord, but that is a part of the policy, my lord, that is operating.
Part of policy to pamper those who have siphoned of state money. Stop. We'll support. Next. In this review application, no document has been produced to show that the office order date number 166 dated 22/2/1995, as well as the statement of GPF account, which was annexed to the writ petition as Annexure 10 series, showing credit of GPF for the month of December 1997 to March 2003 were forced or non-existing, comma. This court is of the considered opinion that in this review petition, the review petitioners have not been able to demonstrate that the appointment of the petitioner as master roll worker with effect from 22 to 1995 as projected together with credit made to his GPF account from December 1997 till March 2023 were forced or non-existent. It is under those circumstances, that following the ratio of Sanjita Roy within bracket Supra, that as the respondent one was successfully able to demonstrate that he has already crossed more than 25 years of service. The petitioner would, the said respondent one was entitled to the benefit of pension and other pensionary benefits. In the absence of anything to the contrary, the finding recorded in paragraph 4 of the impugned order dated 11/12/2020 to the effect that it is not disputed that the case of the petitioner was forwarded by the PHE for regularization of service, and thereafter he was re-engaged in effect from 22 to 1995. Coupled with the said office order dated 22 to 1995 and GPF account referred above, the court does not find any error apparent in the directions contained in the order dated 11/12/2020 to refuse the benefit flowing to the respondent number one from the ratio laid down by this court in the case of Sanjita Roy within bracket Supra. Next para. It is not the case of the review petitioners that non-regularization of the services of the petitioner was inadvertently overlooked by the concerned officials during the pendency of the proceedings of WPC 7022 of 2015 would not fall within the meaning of fall within the scope of any material which was hitherto unknown to the review petitioners despite due diligence exercised on their part. Stop. It is not the case of the review petitioners that the affidavit in opposition filed in the writ petition was based on any incorrect materials placed before the deponent who had sworn the affidavit. Therefore, the present petitioners had taken a risk of filing an affidavit in opposition in the writ proceedings without being acquainted with the correct state of facts. Therefore, no grounds of review has been made out. Next paragraph. The learned counsel for the petitioners has cited the case of state of Assam and another versus Kamrup District Shiksha Sarathi within bracket I bracket close association and others. Review petition 149 of 2014. Sorry, 149 of 2019 decided by the full bench of this court on 13/6/2024. In the said case, the finding of the court was erroneous that those concerned persons had worked for more than 10 years. And therefore, it was a factual error in the which is kept in the order which could have been reviewed. And it is that it is for those considerations that it was held that the case of state of Assam versus Upen Das, WA 45 or 2014, would not entitle those writ petitioners who have not completed any benefit, who have not completed 10 years of service. Next paragraph. Accordingly, on the ground that there is a remote possibility in this case for few views on the subject, and therefore if at all the appreciation of the facts of this court was incorrect, it would make the decision erroneous and not subject to review, as it would require the rehearing of the entire matter afresh. Next paragraph. Resultantly, this review petition stands dismissed. There should be no orders to post. Without the issuance of notice on the respondent or for respondents. Respondent number 1 or for respondents. Take back this. Was Mr. Bhattakur, the department could have shown bona fide even by filing an FIR against those persons who have issued those certificates. Even if they have retired by now, it should have shown the bona fide on your part by registering a FIR.
Yes, my lord. Lack of clarity among the division officials.
That you don't do. I don't know, in English is very expressive languages at times. There is a proverb called hand in glove. I don't know the equivalent of Hindi. Very good example of very good expression, hand in glove.
That is there, my lord.
The stammer may have, the stammer may have, handling glove, the stammer may have.
No, but
But the
whether it-
expression is not same.
expression whether it's same or not, that's right. Yes, next item.
Obliged.
Item 7.
7.
May it please your lordship, we have filed this IA for requiring correction in the order dated 9/3/2019, passed in the National Lok Adalat lordship,
What is wrong?
whereby the statutory deposit ought to have been released to New India Assurance, but instead of that, it has been,
So show from the page, which page, what is the mistake?
lordship in page 5, lordship, para 4.
No, show us from the order,
Order lordship at page 10,
page 10. What is
Ten.
wrong? In which line?
11th line lordship. Upon satisfaction of the claim, the registry shall release the statutory deposit to the respondent number 1 claimant,
Oh, acha, it should be
the New India Assurance lordship.
New India Assurance respondent. It should be respondent.
No lordship, appellant.
Oh, okay, appellant.
Yes, lordship.
By third, this S. Musari, counsel for the applicant. So this interlocutory application has been filed for correction of the inadvertent typing error which has crept in the third last paragraph of the National Lok Adalat order dated 9/3/2019, passed in MSc appeal
14923 lordship, filing number.
MSc appeal filing number, within bracket filing number, or you can say MSc appeal 14923/2018 within bracket filing number. Number is 14923/2018, page 9. Next, it is submitted that the New India Assurance Company Limited was the appellant in the said appeal, and on satisfaction of the claim, the statutory deposit was required to be returned to the appellant and not the respondent of one claimant. Next one. As the statutory deposit is always paid by the appellant, it is apparent that a typographical error has crept in the third last paragraph of the National Lok Adalat order dated 9/3/2019, passed in MSc appeal 14923/2018 within bracket filing number. Accordingly, the said third last paragraph shall now be read as if the security deposit is to be returned to the appellant. New India Assurance Company Limited. Next paragraph. This order shall be read together with the order dated 9/3/2019, passed in MSc appeal 14923/2018 with the filing number. Next paragraph. As this is a case of typographical error being crept in the order, the issuance of notice on the respondent is dispensed with, as no prejudice would be suffered by the respondent number 1. Correction of the typographical error. It just stands disposed of.
Highly obliged.
8.
Okay, it's an IFR correction, my lord. Page 10, my lord, para 7, my lord. Bajaj Alliance General Insurance Company Limited has to be is inadvertently typed, my lord. It should be, my lord, National Insurance Company Limited, my lord.
Oh. And Mr. P.T. Nair, learned counsel for the,
V. Alam, my lord.
oh, sorry, Mr. G. Alam, learned counsel for the applicant, and Mr. R. Goswami, learned counsel for the
Appellant.
for the one, for the respondent for one.
No, my lord.
Applicants OS. Respondent, sole respondent. Next paragraph. This interlocutory application has been filed for correction of the typographical error, which is script in paragraph 7 of the order dated 14/12/2024, passed in MSC Appeal 282 of 2021. Next paragraph, the learned counsel for the applicants has submitted that the appellant in this said MSC Appeal 282 of 2021 was National Insurance Company Limited. Mr. Howe, in paragraph 7 of the said order, comma, typographical error has crept in the name of the appellant by recording it erroneously as Bajaj Alliance General Insurance Company Limited. Next paragraph. Mr. No, the learned counsel for the respondent, comma, in his usual fairness, has accepted the same. Next paragraph, accordingly, the name of Bajaj Alliance General Insurance Company Limited, comma, appearing in paragraph 7 is struck off and substituted by National Insurance Company Limited, comma, the appellant in MSC Appeal 282 of 2021. Next paragraph, accordingly, the directions contained in paragraph 7 of the said order dated 14/12/2024 shall be in respect of the respondent number 1, comma, namely National Insurance Company Limited, comma, the appellant in MSC Appeal 282 of 2021. Next paragraph. This order shall be read together with the order dated 14/12/2024, passed in MSC Appeal 282 of 2021.
Obliged.
Yes.
Item 9.
Right, all of this IA is for, my lord, modification of the earlier order, my lord. My lord, whatever, my lord, OP number 2, my lord, he expired, my lord, the son of OP number 1. So your lordship will come to the operative portion. Page 11 is the order, my lord.
Okay, we'll allow the release.
Yes,
Yes,
Lord.
Sana, right?
Yes,
It's,
that amount of,
actually, some amount was kept for him, and in the meantime, in 24, he died. So that amount can go to the mother. I do not have any.
there are
The
15.
verbal order counsel for the applicants and Mrs. Kadi Mazumdar done it counsel for the respondent. Next paragraph. By filing this interlocutory application, comma, the applicants have paid for modification of the directions contained in the order dated 18/6/2018, passed in MSC Appeal 483 of 2018, and linked interlocutory application being IA Civil 1901 of 2018. By next paragraph, by virtue of directions contained in paragraph 8 A of the said order, sum of rupees 1 lakh was ordered to be converted into 4 fixed deposits of rupees 25,000 each by providing that out of those 4 fixed deposits, 2 would be in the name of the
name of opposite party number 2 and 2 in the name of opposite party number 3.
applicant number 2, namely Manav Roy, and the remaining 2 such fixed deposits would be in the name of
Deepak Roy.
Deepak Roy.
applicant number 2, namely Deepak Roy. And it was provided that a sum of rupees 50,000 would be released. So the applicant number 1, namely Srimati Mamata Roy.
Yes.
Next, ma'am. Nine views. Two would be in the name of opposite party number 2 in the said interlocutory application. And the remaining 2 fixed deposit would be the name of opposite party number 3 in the said interlocutory application. And the sum of rupees 50,000 would be released to the opposite party number 1 to the said interlocutory application. Next, fella. This is by referring to the statement made in paragraph 3 of this interlocutory application, which is supported by the medical certificate of death dated 11/4/2024, issued by the medical officer from Lakhimpur Medical College and Hospital, to the effect that the opposite party number 2 in the said interlocutory application, namely Manav Roy, who was the respondent number 2 in the connected appeal, the MSc Appeal 483 of 2018, had died on 11/4/2024 at Lakhimpur Medical College and Hospital. Stop. Accordingly, as Manav Roy, the opposite party number 2 in this interlocutory application, said IA Civil 1901 of 2018 to expire. Here is made to modify the order dated 18/6/2018 so that the amount earmarked for Manav Roy, since deceased, can now be increased to the applicant number 1, namely Srimati Mamata Roy. Next slide. In a usual fairness from the learned counsel to the respondent does not oppose the prayer. Accordingly, on the projection that Manav Roy, the respondent number 2 in the said MSAP And opposite party number 2 in that in this IA Civil 1901 of 2018 has died on 11/4/2024, which is supported by legal certificate. The claim made in this application stands allowed. The directions contained in paragraph 8A of the order dated 18/6/2018 are MSA so and so and link case IA Civil so and so. Page 12. They will now become it's liable to be released to the respondent number 1. So, sorry, applicant number 1, namely Sumati Mamta Roy. Accordingly, comma. The directions contained in paragraph 8 within bracket 8 is modified to the extent as indicated above. So the recast paragraph 8A shall now read as follows. Out of the said deposited, page 15, out of the said deposited amounts so and so will be converted into fixed deposits of 25,000 each within bracket 25,000 into 2 is equal to 50,000. Which shall be in the name of the applicant number 3, namely, what's his name? Namely Deepak Roy.
Deepak Roy.
And the something is wrong here.
No, Lordship, it was ordered that 1 lakh will be 25,000 each, so 50,000. To each of the claimants, 50,000 was granted. Out of that, fixed deposits were for 50/50 for the 2 sons, and 50,000 as it was to be released to opposite.
So how is 1.5 lakh came? Because we have said
That's why 1.5, Lordship.
it was 1.5.
1.5 only.
We were asked to deposit 50%. Out of that, Lordship allowed them to withdraw
Yes.
this amount.
Okay, okay.
That's why, Lordship.
OP2 share may go to OP1 now.
Okay. And therefore, as 50,000 rupees has already been released, it has been released to number 1.
Not released, madam. The registry asks for modification, that's it. We have filed application.
Then don't say recast. We make a problem then. So accordingly, it is provided that that as per that the share of the deceased respondent, the deceased applicant number 2.
Yes.
Manav Roy.
Manav Rai.
Yes.
Has indicated in paragraph 8A of the order dated 18/6/2018, where it is opposite part number 2, the same would become, as I said, it can be released to the opposite party number, to the applicant, namely Srimati Mamta Roy, who was the opposite party number 1 in the said order. Accordingly, two fixed deposits shall continue to remain in the name of the applicant number 3, and the sum of rupees 1 lakh would be released to the applicant number 1
Yes,
in terms of this modified order. Next one. You can look at the application. This order shall be read together with order dated 18/6/2018, passed in WB, the MLC appeal 483 of 2018 with link case IA Civil 1901 of 2018. Application stands disposed of.
In the appeal, Lordship, the registry has not given any note about service of notice, but that yeah, they have just said ki notices were sent, so registry may verify and give a note on the office note dated 27/23.
You take first step because this is 23.
23, that's why.
Okay.
Otherwise, Lordship,
on respond
President
number?
4 can be striked out because he's the driver. Otherwise, 5 and otherwise the case is pending for long because of service only.
On respond number?
On 4,
Fourth
5 is also served.
5 is served.
Yes, he's the owner of the vehicle.
Okay.
Or else can be deemed served, Lordship, because we had taken long time back on 4.
In the MLC appeal, you say that this is R.D. Mazumdar and counsel for the applicant, for the appellant, submits that notice has been duly served on the respondent numbers 1, 2, 3, and 5. Accordingly, she says that whereas the respondent number 4 is a driver, on whom notice could not be served despite several attempts, his name may be struck off. The period is allowed. The name of respondent number 4, Mohammed Hamidul Ali, is struck off without altering the seriatim of the parties. Next paragraph. By an order dated, order passed today in IA Civil 372 of 2026. This court has taken note of the death of the respondent number 2, namely Sri Manav Roy. So accordingly, he has legal heirs, no.
my lord, no, he was a minor only.
He was accordingly, as the state of the respondent number 2 is duly represented by respondent number 1 and 3, the name of respondent number 2 is also struck off.
And go for final hearing, Lordship.
That's fine. The registry shall do the needful. Next paragraph, as the case is otherwise ready for hearing, that the matter be listed for hearing.
In April.
Preferably in the week commencing first week of May 2026.
Highly obliged.